So I think it's time. So shall we start? Okay. So good morning, good afternoon, good evening, everyone, and welcome to today's webinar titled Reserving for Climate Change, the Emerging Risk Frontier. I'm Ryutaro Yamada, the chair of the International Actuarial Association General Insurance Forum and the Group Chief Actuary of MSNAD Insurance Group. I will be your moderator for today's session. We are pleased to collaborate with the Climate Change Reserving Working Party of the Institute and Faculty of Actuaries to bring you insights on a topic that is increasingly vital in our industry. Climate change is not just an environmental issue, it is a significant emerging risk that affects how we approach reserving in general insurance. As actuaries, we must adapt to these changes, understand the implications on our portfolios, and develop strategies to manage the associated risks. Before we dive into the presentation, I would like to cover a few housekeeping items. Please, yes, next page, please. Yes, please note that speaking capabilities have been turned off for participants. However, we encourage you to engage with us by submitting your questions and comments via the QA icon at the bottom of your screen. We will address your questions and comments during the discussion segment later in the webinar. However, we may also respond to some of them during the presentation. This session will be recorded, and both the recording and a copy of the slides will be made available on the IAA website within the next day or so under the Past Events section. Now, we are fortunate to have a distinguished panel of speakers from the Climate Change Reserving Working Party of the IFoA. Alex Markson is a managing director of Markson Consulting Ltd, a specialist general insurance consulting firm established in 2010, comprising around 15 consultants. Alex established and has chaired the IFoA's Climate Change Reserving Working Party since 2021. Josie Durley is the Reserving and Portfolio Analytics Actuary at Lloyd's Managing Agency, Nephila Syndicate Management, part of Markel Corporation. Sarah Grimshaw is a Reserving Actuary at Major Legacy Insurance Specialist, Riverstone International. Conrad Faragua is Head of Investment and Solvency Risk and leading UK insurer Direct Line Insurance Group PLC. You can find more details about each of the speakers on the IAA landing page where you registered for the webinar. As we embark on this discussion, I encourage all of you to keep an open mind and consider how the insights shared today can be applied within your own organizations. The landscape of climate change is constantly evolving, and it is our responsibility to stay informed and proactive. Thank you for joining us. And without further ado, let's begin with our first speaker. The floor is yours, Alex.
Thank you very much, Rio, and hello, everyone. Thank you for the kind introduction. It's a great pleasure to be, and an honor for us all to be here and to be asked to present to the IAA today on this really important topic. And it's fabulous to see so many live attendees here with us today. I want to start by showing this disclaimer slide and really emphasize a couple of points, not just the general disclaimer about the fact that these are contributors' views and not those of the IAA or the Institute and Faculty of Actuaries, the IFoA, but also to really emphasize the point that we are going to be talking about some live ongoing legal cases in this presentation relating to climate change. And I really don't want anyone to construe or interpret anything that I or any of my fellow speakers say, either in the formal presentation or in the Q&A session, as expressing any particular legal opinion on any of these cases that we're going to discuss, or really commenting on the merits of the competing legal arguments. We are commenting on these cases very much as actuaries in terms of how do we respond and what does it mean for reserving for climate change claims. I also, before I go on, I would like to put on record my thanks to the wider Working Party. There are too many names to mention over the last few years for all of their many contributions, discussions, and efforts in getting our work to this point. And finally, a point, and I'll blank the disclaimer slide because I think it's sort of a lot of text that's a bit distracting. I want to emphasize that the Working Party we're presenting our views. We're not here to moralize on the evils, as it were, of climate change or the challenges. And we really hope that whether or not you have really fully bought into what's going on with climate change or not, that you still listen to what we've got to say. What we're trying to address is not so much about climate change, but about what we as reserving actuaries, how we should respond in our day-to-day jobs. Both in terms of how do we make sure that the technical provisions upon which we opine and estimate how they reflect climate change, but also how we measure and how we communicate the uncertainties that are associated with our estimates. But as you'll see today, we think that the liability side of the balance sheet, the claims reserve, it really does need attention from actuaries, and in part through our work, and to the work of many others across the industry, mean that the tools and techniques to begin this journey are available for firms and for actuaries to make progress. So today we're going to address three areas surrounding reserving for climate change. First, we're going to provide an update on some of the latest developments in our work. And for this, we're going to look at litigation. Today, we're going to focus specifically on some insurance cases to do with litigation, rather than some of the underlying litigation cases that are going on. And we're also going to present a little bit later some of our analysis relating to D&O claims, an analysis of data looking at D&O claims and greenwashing claims, and presenting some of our ideas about how we think reserving actuaries should look to respond. Then we're going to look at what good practice looks like, and we're going to look at that in three parts. These are what we think good reserving or modeling practice should look like in this area. We're going to talk about what our research suggests current practice actually is. And also we're going to share with you some ideas about how you might want to go about communicating what you're doing in this area to your boards and your senior stakeholders. As you will see, as you'll come to find, and you'll see this QR, I'll talk about this QR code in a moment. There's quite a lot of material that we're going to cover today, but also that there is in background as well. So we are going to try and cover things at a reasonable pace. And hopefully this will allow for a block of time at the end for questions and a bit of a discussion amongst this panel. At various places in the presentation, we're going to refer to a number of mini papers that we have prepared. This is partly to streamline this presentation, and also an areas that you can go, and if you want to find out a bit more about this topic, you can go and do some further reading. They are mini papers and there are blogs and there are some presentations on the Institute and Faculty of Actuaries Virtual Learning Exchange, or VLE as we may refer to it, the material that the Working Party has prepared and that you might find useful to refer to in due course. So there's a QR code here that should take you to this virtual learning exchange on the Institute and Faculty of Actuaries website. If it doesn't work first time, do have a couple of goes. It generally does work, but sometimes there are some glitches in the system. But hopefully you'll find that material useful. So here is our agenda for today. It's in 6 segments. The 5 golden boxes are for the planned presentation element, and they're going to be, as I said, a form of mini presentations. And then the blue boxes are for Q&A and panel discussion. But we hope that there is going to be something for everyone, wherever you are on your climate reserving journey. Okay, so to kick off, I'm going to present the first of our 2 litigation sections. In a number of previous presentations that this Working Party has given, and also indeed many presentations given that you will come across on climate change, the focus has tended to be on the interesting underlying cases that have been going on. And these are cases where typically cases where CO2 emitters, carbon dioxide emitters, and greenhouse gas emitters are the defendants. And there is little mention that's been made of insurance. So while those cases are really important to understand, not least because they reflect some of the legal innovation going on in this area, and perhaps some of the changes in social attitudes towards compensation and societal changes relating to climate change, and that underpins much of our work. However, today I'm going to look at some of the significant insurance cases that we've identified in our research. And then after that, I'm going to step back and highlight a few things to look out for over the coming year. While I'm not going to talk about the underlying litigation, there's a link here and obviously the QR code as well to a short paper that we've put together that covers 3 of the important cases that we've been tracking. Now, the insurance cases that I'm going to talk about, as I said, are going to exclude those relating to D&O and greenwashing claims, and Conrad's going to speak about those a little bit later. And just to be clear, although there aren't that many insurance cases that have been reported, this isn't an exhaustive list of all of the cases, but we think these are the ones that are really worth talking about. So the first case was quite a positive one for the insurance industry. It dates from 2012, and it was a case brought by Steadfast Insurance Co. Against its policyholder, the energy company AES Corp. Now, in this case, Steadfast successfully obtained a declaratory judgment that it had no duty to defend AES. If you're interested, the underlying case was a case brought against ExxonMobil, and that case alleged that global warming from greenhouse gas emissions had caused sea levels to rise and that had overwhelmed this, as you can see from the picture, this low-lying Alaskan island, the native village of Kivalina. So the insurance case involving Steadfast and AES was listened to by the Virginia Supreme Court, and that case held that Steadfast had no duty to defend or indemnify the energy company for 2 reasons, principally. First, there had been no accident or occurrence that could be defined that triggered the coverage. And secondly, because cover was not provided for the intentional act of extracting and burning fossil fuels. We'll come back and talk about this a little bit in the third case I'm going to look at. The second case that I want to mention was less positive for insurers. This case arose from an explosion at a chemical factory operated by Arkema. For those of you who haven't come across Arkema, Arkema is the company that makes consumer products such as Bostik and Bostik glue and Blue Tack for sort of sticking things on your walls, amongst many other consumer and commercial products of this nature. Now, in 2017, flooding in Texas caused by Hurricane Harvey led to fires and an explosion and the release of the numerous toxic chemicals. As you might expect, regulatory and private lawsuits followed, and these were covered by Arkema's environmental liability policies. So far, so straightforward. But the point to draw out are 2 things really to note. The first is that the liability loss was triggered by a natural catastrophe event. And so that highlights the importance of allowing properly for the linkages between liability losses, and you need to include liability losses when you're thinking about your event modeling. And the second factor, and the second point to really draw out is that one of the reasons that this claim arose was that there were changing flood patterns that had been mapped and developed by the bodies responsible for doing so. But these changes have been ignored by both the insured and the insurer. And this gives rise to a really important lesson about climate change, is that the perils are going to change and the exposures are going to change. And some of the areas for liability losses are those that arise where there's been a sort of negligent response and an inadequate response to change in light of those underlying changes in perils. The third insurance case concerns a case to do with Aloha Petroleum, and it relates to its defense in a major climate case that is going on between Honolulu, the city and county of Honolulu, and Sunoco, and a series of other oil majors cases. And if you Google this, you will find out lots of details about that case. And if you look at the link that we provided, you'll find details about that case as well. But what's interesting about this case is that the ruling that came out in early October from the Hawaiian Supreme Court, it differs from the Steadfast ruling in some important ways. And I think it's important for actuaries to be aware of this when thinking about reserving. So the underlying case is actually at the US Supreme Court, and that hinges on whether the case should be heard at a state level or a federal level. And that's quite critical in terms of understanding liability. But coming back to the insurance aspects of the case, what the Hawaiian Supreme Court ruled was two things. Firstly, even though the burning of fossil fuels was an intentional act, the reckless emission of greenhouse gases could be treated as an accident or occurrence for insurance purposes. And as you can imagine, that's bad news for the insurers. However, the ruling also found that even though carbon dioxide might not be a pollutant, because it's, we all breathe it out, the mass emissions of greenhouse gases into the atmosphere should and could be thought of as pollution, and therefore could be excluded by pollution wordings where they were in place. Now, I've no doubt that both sides will seek to take parts that they lost to the US Supreme Court, so the battle shouldn't be thought of as being over, but it's clear that simple wording issues will continue to be fought over. So, what should we look out for in 2025 and beyond? I want to suggest three themes that I think are worth looking at. First, the way in which some of the major claims that we've previously discussed and I mentioned today, for some of them, will develop, not least the US question of which matters are reserved for federal courts and which can be heard by state courts. Second, I think the ongoing perennial argument and coverage and the questions of pollution exclusions and intentional acts and how climate change and climate change liability is treated by insurance policies. And thirdly, the effects of emerging litigation. What new classes of insureds should we expect to emerge? So a couple of recent examples. There are those of counterclaims, where the carbon dioxide emitters, for want of a better way to describe them, they target those organizations that are trying to hold them to account in legal actions. And then the other interesting twist on some of the climate litigation is what is termed green on green litigation. So an example of this might be someone who's trying to or planning to build a wind farm in some offshore area. What should be the resolution if that conflicts with the migration path or the breeding grounds of a school of whales? So no doubt it's a complicated world out there. There's a lot changing, and the sands of how climate change and climate change liabilities evolve continue to shift. So that concludes my section on litigation. I'm now going to hand over to Josie, who's going to talk to us about how we might go about modelling climate change. Thank you.
Alex. So yeah, as Alex said, I'm going to talk a bit about how to model climate change reserves. Next slide, please, Alex. So I'd love to give you a magic bullet and tell you to uplift your reserves by X%. A one-size-fits-all approach, but unfortunately, the future landscape of climate change-related claims is uncertain. And it will be entirely different for different lines of business and even for different portfolios of the same line of business. However, it's important that we have an informed means of assessment to understand how climate change may impact our books. Next slide, please. Perfect. So due to the uncertain nature of climate change, we found that the best way to do this is to do a qualitative assessment where you split climate change into different categories of risk and then consider the impact of each risk on each individual line of business. So you'll see on this slide a split from APRA that we found very useful when doing this. And additionally, in some cases, you might want to further subdivide these risks. So if you've got a class business that's particularly affected by physical risks, for example, you might want to further split this into acute and chronic impacts of climate change. Next slide, please, Alex. So when looking at each line of business, the impact of a risk on that line of business might be unclear, but the impact of a risk on line of business, the impact might be unclear, but that's absolutely okay. And it would be good to have a think about what impact the risk could have, how it could come in, and if there's anything that can be done to avoid it. It's worth noting that all of this is in a recently released blog post that we've done on our VLE, which gives a lot more detail and examples and should help you guide you through the method. And it's available for people outside of the IFoA as well. You don't have to have an IFoA login to get to it. So do check that out. Next slide, please, Alex. So this slide shows you what the output of your analysis might look like, although with a lot less words and comments than you would likely have in yours. This, as you'll see, there are sections which highlight what needs to be monitored going forwards, where there might be claims that already exist, and things that can be done now. And each bucket could be split further into whether it's been explicitly modelled, needs to be explicitly modelled, or there's implicit modelling already within your reserves, or if no allowance needs to be made. Okay. Next slide, please, Alex. Your analysis should give you a clear direction of where to focus your attentions. It may be that different risks require different reserving actions, for example, percentage uplift, trend analysis, a specific allowance, or nothing but monitoring needs to be done. It's important to work with other areas of the business on this analysis, as it will likely be useful to more than just reserving. For example, some classes it may highlight important pricing or policy wording changes that need to be made, or highlight where a capital allowance needs to be made, as well as any reserving actions. It's also worth considering the business as a whole. Could the insurer be sued for financing past emitters before and therefore contributing to climate change? And on that uplifting note, I'm going to hand back to Alex to talk about considerations for writing your board report.
Thank you, Josie. What I'm going to now do is to share with you some of the working party's ideas regarding how to share the results of your modelling with your board and your senior management colleagues. I've got a slide on each of these three topics. First, the priority is actually to be clear about what you want to achieve. It's really not about pursuing a political agenda. Next, I'm going to show you an outline for how we think you might go about writing a report on climate change reserve exposures for the 2024 year end. And finally, I'll share some thoughts about how we think you can go about structuring your discussions around uncertainty so that you can have something action focused and not get bogged down in some of the more unknowable issues. Good actuarial board communication is all about providing the information that your recipients need to know. When we're successful with our communication, we provide our colleagues with a consistent mental map of the issue at hand. So I want to suggest these three simple goals for your climate change reserving communication. First, it means you need to explain the reserving issues arising from climate change, how and why they're important for your firm, and where the key areas of uncertainty and the knowledge gaps arise. But you also want to help your firm to reach a common position about which elements require explicit additional reserves and which don't, and whether this is because there is no exposure or because you already have an implicit allowance in your reserves, or because you consider this to be an emerging risk issue for which the firm should hold capital and not actually have an explicit reserve on the balance sheet. Finally, you want the reserving team to have a clearly defined role within your firm's wider surveillance of climate-related developments, so that you can use your reserving skills to join the dots across the many moving and interconnected parts. So that's the theory, but what about the practice? Well, one of the elements of feedback the working party has received in the past from our previous work has been the desire for many of our audiences to have some more specific examples or concrete examples about how they should go about structuring a reserving report to do with climate change. And so with this in mind, we've spent some time thinking about what a climate change reserving report might look like. Now, I've put on here a list around the sort of set of headings, but I don't want to suggest that you follow this slavishly. It's a possible approach you might want to consider, and hopefully this will prompt some ideas. But this gives you an idea of a structure that you might adopt that steps from the risks that are faced by each line of business, starting at the beginning on A, through understanding your current level of knowledge for each of the elements you're looking at, to a place when you can start to advance a set of measures and metrics that will help you prioritize the various elements you're looking at. As you can see here from the link at the bottom, and if you follow the QR code, you'll get to it. We've prepared a short paper that sets out these ideas in greater detail and included some examples of what we mean by this. And follow the QR code or this link in the physical document to get to the relevant place on the IFoA's virtual learning exchange. And whether you use our ideas in this paper to develop a separate standalone report on this particular topic, or whether you find this useful as something you might incorporate into a general year-end or future reserving report, I'd really like to ask that you do give us feedback on your experience of trying to use this and these ideas to prompt your development of how you report on this work. Finally, then, there's the question of how do you talk about uncertainty in climate reserves in what you can consider to be a helpful or constructive fashion, rather than something that sort of seems to suggest a panic approach. Now, it's easy to focus on current issues, such as which way will the US Supreme Court land on certain key issues? Or even what will the election of Donald Trump have on the way in which climate change and climate change liabilities evolve? And of course, we know, and certainly the recent events in Syria have shown us, geopolitics can throw up some very unexpected and very sudden chains of events. And there is nothing like the prospect of rising energy prices and inflation to change priorities of consumers and potentially change social attitudes. Well, these are all very interesting, but I think what's really important as actuaries when writing your report is to distinguish between what I term general uncertainties and specific uncertainties. So by general uncertainties, as I put down here, I mean the aspects of climate change that will affect reserves, but for which you have little or no ability to control. For example, how fast and how far will the planet warm? What will the ultimate costs for society be of climate change? And how much of these costs will fall to insurers? But then there are the specific uncertainties. These apply where insurers can choose to take steps to narrow down the uncertainty that they face, and whether this is through tracking claims, through analysing underlying exposures, or looking at historical policy wordings to understand where exposures might be. And I think that it's really helpful if you start to separate out and start to explain these two types of uncertainty, the general uncertainties and the specific uncertainties separately, to help you build a proper plan of action for your reserving team. So in summary, having a clear aim of what you want to do, a structured presentation of the facts and your measures to do with climate change, and an action-focused framing of uncertainty in your board reports should stand you in good stead to be part of your firm's response to this important area. It's now my great pleasure to hand over to Sarah Grimshaw, who's going to take us through the results of our recent survey of current reserving practice in the area of climate change. Sarah.
Thanks, Alex. So as a working party, we're continuously looking into how best we can support reserving actuaries in responding to climate change. We carried out a survey this year intending to understand if and how reserving for climate change has progressed since we carried out a similar survey in 2022. So let's have a look at some of the results. Next slide. Next slide, please, Alex. So we had over 60 respondents from a mix of businesses, with just under half being from the London market and reinsurance companies. This is a similar mix to last time. By reserve size, the largest classes were property, casualty, which includes FinPro, and motor. The graph on the right shows how informed respondents consider themselves to be on climate issues. This shows that 78% consider themselves to be aware of and at least somewhat informed on the latest research. This is the gold bar in the middle of the chart, which has increased from 64% in 2022. The results showed that respondents foresee reserving challenges across most classes of business and territories over the next year. These are the navy bars on the graph, and even more so over the next 5 years, the gold bars. Property classes are expected to be the most challenging, and North and Central America the most challenging territory. I think it's interesting to note that Western Europe jumps up into a close second place, though, over the next 5 years. Most classes and territories show that respondents are less concerned over the next 12 months than the next 5 years, suggesting that climate change is not an imminent concern for reserving, and it's more thought of as a future problem. Okay, next slide, please, Alex. The survey also asked for the top 3 reserving climate change concerns over the next 5 years, which are the navy bars, and the next 20 years, the gold bars. At the top, we have changing frequency, closely followed by changing severity of claims, which were both selected by nearly 70% of respondents as being the top concern over the next 5 years. Over the next 20 years, new claim types jumped to the top concern, with nearly 60% highlighting it. And latent claims also increase from nearly 30% to about 45% as we go from 5 to 20 years. Okay. Next slide, please. So despite all these areas of concern, there's very limited current allowance in the reserves. This pie chart shows that 71% of respondents aren't making any allowance in their reserves, with 36% not even considering it. That's the Navy segment on the pie chart. 9% of respondents have an allowance between 0% and 0.5%, and 11% have an allowance of greater than 0.5%. So it's broadly in line with our survey results from 2 years ago. However, people aren't doing nothing. 39% are starting to consider climate change in their reserving through looking at potential scenarios. 14% are making expert judgment loadings, and 8% are making implicit allowances. It's probably not a coincidence that 39% also regard scenario analysis to be minimal acceptable practice for climate change reserving. 76% of respondents think scenario analysis is good practice. Roughly 30% consider exposure assessment, flagging climate-related claims, and keeping up to date on latest market developments to be minimal acceptable practice. Only 20% of respondents said climate-related reserving is viewed as important by their organisation, and it's mostly driven by the chief actuary and/or the risk function. Okay, next slide. We've received some good feedback on the working party's contribution so far. Over 53% said the paper we produced in 2023 was helpful. Hopefully this isn't too biased a sample. Some of the feedback can be seen on the screen in the bubbles. We asked what new content would be beneficial to reserving actuaries. You can see from the graph that climate risk scenarios were the most popular of the suggestions given. Around 50% said that heat maps would be helpful, like the one that Josie showed earlier. The limiting factors to reserving for climate change are, unsurprisingly, lack of resource, data, and expertise. There's a wide range of views of what is needed to develop current approaches, but there is definitely a demand for resources and collaboration. But some respondents still do not consider climate change to be a reserving concern. If you'd like to discuss the survey questions or responses in more detail, please do get in touch. We will also be publishing the results on the VLE soon. That was everything on the survey. So with that, I'll hand over to Conrad for more detail on litigation.
Thank you, Sarah. So in this section of the presentation, we will expand on the work that the working party, the good work the working party has been conducting over the last year. And in a paper reserving for climate change, we've introduced heat maps as qualitative tools that reserving actuaries could use to evaluate climate risk exposures within their portfolios. The case study that we've got in the paper, which was also available on the VLE, focused on 2 classes of business, namely property and D&O. And we introduced the concept of a heat map with the red, amber, green ratings, and on one side of the axis, it had the various claims or triggers of drivers of claims for the 2 classes of business. And on the other dimension, we had the climate-related risks that Josie highlighted through and alluded to earlier. So since then, over the course of the year, we've performed a deep dive, and we've looked at 1 class of business, the D&O class, and the scope and purpose of this presentation is actually to give the quantitative and qualitative findings from our work. So as you look at the second bullet point, why does climate litigation, why are D&O policies affected by climate litigation? So more than ever before, company directors and officers are exposed to more legal scrutiny, including shareholder litigation and regulatory investigations. Increased oversight duties, extent of climate change governance and disclosure requirements, and directors may face liability for not taking sufficient action to address environmental issues like climate change. So on this work, and I'd like you to focus on the 5 main causes of D&O policy claim, which we came up with in our paper, which we're referring to as triggers A to E. So if I look further in detail into each, so A are litigation cases against companies like fossil fuel industries and large carbon emitters to compensate for damage caused from their activities. B means failure to adapt, companies' failure to adapt or directors failing to take appropriate action. Failure to comply with regulations as a breach of duties, which is more on the increase as more climate litigation is being enacted and enforced. Misrepresentation of exposures, disclosures, or underreporting, which is known as greenwashing. And finally, trigger E is misleading information or greenwashing affecting various industries. And I've put 2 cases on the slide, recent cases on the slide. If we go then to, now let's focus, so that was the context. If we now focus on the quantitative side of our of our research, if I go to the next slide, what was the context? What's the research methodology? So in here, we've looked at a comprehensive list of climate litigation cases, and we've sourced this from an open database from the Columbia Law School or Sabin Center for Climate Change. This database has got 2 main data sets, so the US and non-US cases. We are focusing our analysis on the non-US cases because the US cases are classified by type of litigation rather than by the course of action. We've taken those, then from that data set, we have filtered out only cases against corporations. Why? Because these could only come to end up as a D&O claim. And also over the years, we focused on 6 years, 2018 to 2023. Why? Pre-2018, the cases were quite sparse in the years, and 2024 is an incomplete year. And we have also mapped the course of action in that database to the 5 triggers that I referred to above, that I referred to earlier on in my presentation. And I just wanted to point out that our analysis is at a point in time taken on in May 2024, and there may be an element of IBN other cases are attached to the filing years. So that was a broad overview of our methodology. If I go to the next slide, let's share some of our key findings. So in this slide, we're simply plotting the number of cases by year 2018 to 2023, and the various stacks includes bars which are colored related to the 5 triggers. Immediately, what do we see? It's immediately apparent an increasing trend in climate litigation cases against corporations. Comes to no surprise. However, what is noticeable is the gold. If you look at for each filing year, you're looking at the gold bars. There's an increase in greenwashing cases particularly over the last the 3 years, 2021 to 2023. And the second largest trigger is failure to adapt, trigger B. What's also interesting to note is climate inaction or past emitter cases have been reducing over time as well, which we're calling that trigger A. Moving over to the next slide, we split the cases into a different cut. So on this slide, in short, we are looking at countries, and the largest countries with the largest climate litigation cases, and with an overlay of the GDP per capita for each. Well, if you focus your attention to the two bars on the left, you've got Brazil and the United Kingdom. I think what's interesting to note there is the different shadings, where you're seeing different shadings, that is different triggers for the different countries. So if I look at Brazil or the first instant, most of the climate litigation cases in this country relate to failure to adapt or comply with regulations, leading to lawsuits claiming physical damage against the government, failure to adapt or comply with regulations, or requesting revocation of licenses and permits. On the contrary, if I look at the United Kingdom, similarly Australia and Germany, you see the gold in the bars is quite quite significant why there are more cases related to triggery, misleading information or greenwashing. So effectively, the key message from this slide is that the country where one is in makes a difference, and different triggers and different climate litigation cases come from different countries, and there's also is a correlation between higher GDP per capita. You tend to have more cases related to one trigger than countries with a lower GDP per capita. Moving on to the next slide, we're now looking at cases by filing year and status, and in this quite busy slide, what we're trying to do for each of the filing year, we're coming up with the number of cases that have been decided, that are pending, or that have been withdrawn. In short, the key message from here is that out of the cases filed between 2018 and 2023, around 34%, sorry, have been decided, with the rest are still pending. This is not unrealistic, because for those of you working in D&O claims, you know that D&O claims take around about, from point of notification, take around on average 5 to 6 years for completion, and up to 10 years. So most of these cases have a long leg as well. But what's interesting to note is that some of the triggers, like misleading information or greenwashing, triggery, have got a shorter lag compared to cases like climate attribution for past emitters, which tend to have a longer lag. So those were, in a nutshell, our quantitative findings. We've also, the title of this presentation is The Emerging Risks. We've also looked at what are the emerging issues, and we've had conversations with a leading D&O underwriter to understand what is the industry feedback and what are the emerging trends. So in short, in terms of D&O litigation, so the largest anticipated growth trend in D&O litigation over the coming years is going to be environmental and climate related, mainly specific concerns relating to class actions from lawyers, particularly in Europe, because most of the legislation has been enacted in Europe at this juncture. And litigation concerns, if I look at again and mention triggers, are mainly related to trigger C, which is failure to meet local legislation and inability to evidence progress in their transition plans. And therefore, what are the underwriters' concerns at this juncture? We're looking at an increasing concern from the uncertainty associated with litigation, particularly relating to clients who have made climate commitments publicly and in their annual reports, with the first deadline being 2030. And effectively, as 1 year is 2030, are the clients able to keep up with these commitments? And if not, this could potentially result in adverse impact and a D&O claim. And how may underwriters respond to these respond to these concerns? They could focus more on risk selection, management of portfolio risk, like, for example, restricting or excluding climate-related coverage, increasing the rates, or reducing line size. So from a strategy perspective and from a practical risk management perspective, it is likely that there will be more stringent underwriting criteria and greater customer arrangement to provide more support to mitigate exposures to litigation. So moving on to the last slide, what are the considerations for reserving actuaries from this background that's been given? So if we look back at the quantitative research, understand the D&O triggers, different ongoing claim trends across different jurisdictions. We've seen different jurisdictions having different types of litigation cases. We aim to give you more insight on that. Monitor your recent trends in your claims frequency and severity and any shifts in claims payment patterns. For those of you having backbook liability policies already written, and any ongoing litigation, particularly for high emitting companies, carry on assessing these exposures, these potential future exposures. And then from a qualitative perspective, be aware of underwriters' concern in relation to future uncertainty and potential changes in strategy. We all know that it's likely that there is going to be a cliff edge over the next years. When that will happen, it is not known. So basically, underwriters have conversations with defense counsels who have their ears on the ground, can preempt any such trends, and therefore having these conversations is crucial. Also consider allowance for uncertainty in the claims reserves. It was already highlighted by Josie in her presentation earlier. And finally, the final point that I'd want to make is communication is key. Communicate with key stakeholders in the organization, or I've already mentioned underwriting teams, head of product development. Also, climate teams within the organization, they will have more information, more background, and other areas like risk management who would also be making their own research, and they would be in touch with any regulatory changes that might be coming through. And also look outside your organization, move across the insurance sector, understand and have conversations. Thank you for your attention, and I'll now hand over to Alex.
Thank you, Conrad, and thank you to all of my fellow speakers. So what we're now going to do is we're going to have a bit of a chance for a panel discussion and take some questions from the from our delegates attending in the live session. Please do put your questions in the chat. Really want to encourage thoughts and views and observations and any instant feedback from any of you. Please use the Q&A box on the bottom right-hand corner of the screen to submit your questions, and we will try to answer them. And I see that we've had one question that has been answered online, but I thought it was a really good question, probably worth having the opportunity to just talk about a little bit more. So I'll give Josie a bit of a nod, because I think she may be the one who wants to take the lead in answering this. But the question was, and just to read it out, where does an uplift, or where does the uplift for climate reserving sit? Is it a separate reserve, or is it something that gets incorporated into the RBNS, the reserve but not settled, or the IBNR, the incurred but not reported part of reserves? So Josie, do you want to sort of kick off on that? And Sarah and Conrad, let me know if you've got any sort of specific thoughts. I've got a couple of to make as well, but off you go, Josie.
Yep, cool. So I think it depends on what line of business you write. There's definitely likely to be stuff sitting in your IBNR, because there's lots of uncertain stuff that's yet to unfold, so it's not incurred yet. Or that it has incurred, but it's not been reported yet, so there's a short period of time there, but also the general view of unearned IBNR, so URR sort of thing. It will sit in there as well. But then once it has been reported, there could be a chance that, for example, your claims team are using old flood maps, like in the Arcama litigation case that Alex talked about earlier. And so, for example, there could be underestimations from your claims team if they're using these old flood maps, and actually the flood risk has moved on from there, and the impact is likely to be a lot more. That's just one example. But as I explained, there's some modelling work that we think you should carry out on a qualitative basis, which should give you a bit more of an insight into what risks will impact your book. And as a result of that, you'll see how they will impact your book. And you could additionally add a flag of whether it will affect reported and unreported claims, or just the unreported claims.
Yes, I think that's very well made point. I think, I mean, to me, one of the things that sort of jumps out of this question is you've got a sort of a bifurcation in terms of sort of thinking about the different elements in the sort of the climate taxonomy as to where the issues sit, and whether it's a property claim where it may be about thinking about the sort of changing development patterns that you want to use. Certainly one of the things that we've explored has been some of the sort of the way in which climate can cause demand surge and claims inflation to change and evolve in terms of its profile. So it's worth having that at the back of your mind. On the liability side, it can become a little bit more challenging, whether you want it to be an explicit liability or an implicit allowance, in terms of where it's there, because there's certainly, we think there are some classes of business where there will already be climate claims coming through. They may or may not be identified as climate claims. And one of the things we've talked about in our previous work has been the phenomenon of silent climate claims. And certainly that's one of the things that you're finding in the adaptation claims that arise, where people may choose, for example, on a professional indemnity claim, not to use climate as as a factor in the claim pursued, because they think that politically is unhelpful and not necessary. Equally, on liability, and certainly on the major liability, it may be that firms will want to hold a general IBNR, but not identifiable as such as a particular climate liability. Okay, we've got a number of other questions that have been coming in, and I'm just trying to work out the order in which we take this. I'll take them in the order. So the first one for our panel. IFRS 17 and Solvency II require claims reserves to be at a best estimate level. How do you justify to your auditors that reserves, including an uplift for climate change, are still best estimate, given that it includes a high amount of actuarial judgment? Sarah, do you want to pick up and respond on that one?
Yeah, I'll give that a go. So obviously best estimate is a range anyway, and I think we could argue that there's actuarial judgment in a lot of our best estimates, particularly on liability classes. But we're never going to get the answer right. But if you think that there is some exposure in your book to climate change, then surely there would be some climate change reserves within your best estimate. Otherwise you're potentially under reserved. And yeah, I think auditors, the message we're getting from auditors is that they are wanting to see more in relation to climate change, and certainly from the regulators.
I think that's right, isn't it? And I think it does come back to the best estimate, and I think not including an explicit allowance may be not having a best estimate reserve, or including an explicit allowance. The art and the challenge here is about thinking about what is it that gets your reserve to a best estimate. And there's no clearly right or wrong answer, and it is difficult. And part of the reason, motivation for our work, is trying to help actuaries marshal their arguments and understanding so they can actually feel they are in a position of getting to a best estimate.
I would also say that if your best estimate doesn't include climate change allowance, being able to justify why it doesn't, I think it's perfectly reasonable, and there will be people who don't have any impact from climate change. So it's perfectly fine for you to not have a climate change impact if you can also justify that it wouldn't be impacted by climate change. So having done that research and looked into it and checked.
Great. Okay, I'm going to go on to the next question. I just want to suspect how many to answer, which is, how are boards responding to reports from actuaries and underwriters on climate risk? And is this changing? And what sort of training and wider education is key? So my observation from what I've seen is, while there's been a substantial amount of material going to boards on climate change more generally, and there's been a push for climate disclosures, which are very much focused on the firm's climate emissions and the like in the level 1, 2, and 3. What we're saying is actually that there seems to be relatively little content going to the board in an effective fashion about how is climate change going to affect the liabilities on the balance sheet. Now, it may be that there are other more pressing things, whether that's exposures to cat risks or whether it's exposures on the asset book are seen as being greater priorities. But part of the challenge is just trying to get one's arms around what the exposures are in the liabilities on the balance sheet. So part of the education is about that this is an issue, and it is an issue to think about in the balance sheet, the largest single number on the balance sheet. But there's sort of this increasing awareness that liabilities are coming through, and I think that the first part is training about where's the litigation going. Then it's the understanding that as ever, when there are large areas of litigation and liability, that is inevitably part of that will affect insurance companies, and helping boards just to understand the issue. And it's going to take time, as all education and cultural changes things need. I don't know whether any of the panel wanted to comment on that, or whether we should move on. No. Okay. Good. Okay. So a question here about, would this claims reserving uplift be in addition to something like an Enid reserve, or is there an overlap between these components? I think it's a very good question. I don't know, Josie, whether you wanted to circle back and just pick up on that one.
Yep, sure. So there possibly would be overlap depending on what the allowances that you're making are. But also there is a good chance that you've already got climate change allowance within your reserve. So you might have seen a trend over the last few years of an increase in, say, water pipes breaking because there's been increasing amounts of low temperatures in specific areas, and we've seen this climate weirding allowance. So it might be that you're already allowing for some stuff in your book. As I said before, the most important thing is just having a look, like have a look at your book and figure out whether you've got any allowances in there already. You might be doing trend analysis and saying, oh, there's a trend here, we'll include that, but that might be not just inflation, but it might also be an allowance for climate change in there as well. So just have a look at your book, and then it would be in your data, so it wouldn't be part of your ENID allowance. I think that's sort of my answer, but there will be stuff that's in your ENIDs as well.
Now, a quick question. We had a question about why there was no focus on US risks. I wonder whether the person who submitted that question could just sort of clarify a little bit more about what they meant, because there's we probably did touch on US risks in a number of ways, but we probably weren't super explicit. But if you could just expand on what the question meant, then that'd be really helpful. Thank you. Coming back to the other questions, we've got one from Yanis Pitaris. How, in your view, might reserving for long-term non-life insurance contracts, such as 12-year-long construction insurance, be affected by climate change? Would anyone like to pick that up?
I can do that
Go for
one
it.
as well,
Great.
unless anybody else wants to grab it. For example, we could imagine that for a long construction project, actually the flood, this is again going back to the flood risk, is quite a good example. The flood maps might change over that 12-year construction project. And considering there's been lots and lots of projections, people do it projecting out till 2020, 2050 and beyond. And there are projections of where these flood maps might go. So considering where your risks might change over that 12-year period will be key in that. Because it won't just be that your flood risks will change, it'll be lots of different areas. And people like the IPCC have done maps of what different types of physical risks might impact different areas of the world. So they've done a globe with, you can pick the different physical risks and it will highlight what different areas are impacted by that. So that's quite an interesting one if you do want to check that out.
Thank you. And I think that possibly sort of answers the other question from Yanis about should reserves for past and future claims be adjusted for climate risk, which I think the answer is yes. And I think particularly for, as Joseph was saying in response to that question, I think you've got a long-term construction contract. It is important to think about the unexpired risk and whether the pricing actually reflects and the reserving on that actually reflects the ultimate position. If you think that climate is going to have a significant impact on that, it's worth being aware and taking that into account. Now, I'm going to come back because I think we've had a clarification on the question about the US risks. And I think I know what it is to do. It's probably one for Conrad about why his chart showed Brazil and UK as having the largest number of cases. And there's a relatively simple answer to that. So if I ask it slightly differently, firstly about what was that chart showing and why is US not on there? And the second is why are Brazil and the UK the top that were in that chart?
Okay, thanks, Alex. So at first instance, in the data set that we've reviewed, the question is fair? Because the US is one of the most litigious countries. So why it wasn't in our database? The simple answer to that is that when we've looked at the database, we couldn't. The database was structured as such that the cases were by type of legislation rather than action. So we needed to do a lot of work. That's something that we're possibly contemplating to do, and over the next years we've embarked, our working party embarked on a journey, and there's definitely a lot of work to do, and it's on our to-do list as well. In terms of the two countries that answered the question why US has not factored greatly in our presentation. As to the second question, why Brazil and UK, I think Brazil has had a large number of cases mainly related to climate and action, revocation of licenses, etc. by a number of countries, judging by the way it is and located, and there's the Amazon forest located in Brazil. And secondly, the UK has the largest number of cases mainly related to greenwashing, false advertising, and other cases which have topped up the list.
Thank you, Conrad. Yes, very much just to understanding what the data was. But yes, there's an interesting history between the two databases that the Columbia Law School maintains for US and non-US. And there's sort of the sort of separate historical genesis, which means they're structured differently. And I'm sure that if one started again, one might do it differently, but that is, you know, the way the data's been marshaled, and I guess it's going to be a challenge to ask them to do it differently. That probably dovetails quite nicely to the question from Alan Marshall about what other experts are actuaries working with to arrive at appropriate judgments for reserving, and related to this, what actions can reserving actuaries take to develop appropriate knowledge on climate-related aspects. So I can kick off with a couple of comments just on the experts that we've spoken to, and then I'll sort of throw it open to the others. But certainly talking to lawyers is going to be a key element, and claims handlers as well, just to understand some of the legal dynamics here. And I guess one of the really important things is trying to make sure that the question doesn't focus on the rights and wrongs of specific cases, but tries to identify the trend and the evolution here. And one of the things that we really want to help actuaries to understand and also to marshal, and this probably speaks to the second part of the question about the actions you can take, is just understanding not just the snapshot, this is the nature of where a particular case is or isn't, and whether this case wins or loses, but in a sense, the weight of the direction of travel, of social change, societal attitudes, and litigation. Because one of the features is that, as we've seen over, you know, if we take our long-term view, is that where there is a societal wrong that needs to be righted, very often the legal community over generations changes the way the rule book works and thinks, actually, no, this does need to be dealt with in a new way. And they sort of essentially, as we saw with asbestos, they develop new fields of law to tackle the problem, and new legal theories. So I think the claims handlers and lawyers initially, but I'm sure that others are going to talk about their conversations, interactions with underwriters. Certainly Conrad, as we know, spoke on D&O. So who would like to take that part of the question?
I can take part of the question and probably relate to experience. Basically, yes, underwriters are really important for D&O and like other class of business like property. Understanding trends, what are they actually seeing, what's coming through the claims. I think one team which is also other important is the exposure management team. They might have climate scientists employed as well. So probably that team would be running the modeling, cat modeling, etc. They would know what any trends that are coming through and actually be able to guide the company, the insurer, the particular insurer writing that class of business into what are the main trends? Are these climate related trends, or are they kind of part of the claim cycle, and therefore allow for them in the normal way in reserving? Other areas that one might look into, unsurprisingly, is also the compliance team, which you tell me is quite strange. Why? But there's going to be ongoing legislation coming in as well, which may particularly affect all areas of the business and even reserving as well. So one could relate to these as well. Over to you, Alex.
Yeah, thank you. Anyone else? I think, Sarah, you wanted to say something.
Yeah, I guess just more on what actions can reserving actuaries take. So obviously there's not a lot of data available at the moment, but you can start asking for that data. You can talk to the claim handlers and make sure they're flagging any claims that they can, that are easily identifiable as climate related. And you can start building up those data sets. And you can look at what is available, kind of the market available. There's a lot of big databases of litigations and things like that that aren't directly related to insurance, but you can start thinking about it. And it goes back to Josie's point on kind of exposure assessment.
Yes, I think that's absolutely true. And the more we talk about it, the more we start to, amongst ourselves and with other professionals and disciplines, build the knowledge of what the kind of the big picture issues are. And certainly what we're sort of suggesting in our section, if you look on the communications and the paper on the learning exchange, is about trying to think about what's the state of knowledge for a particular portfolio. How much do you know? Where do you want to invest your effort? Because we know that the idea of going through every single historical policy written over the last 100 years is preposterous and unrealistic. So trying to work out where the investment needs to be made, and where there's sensible payback to the board, so that the reserving actuary's role is taken seriously and the contributions is taken seriously. Now I'm going to, there's a question on life insurance, which I'm going to skip past because I'm just not sure that we're really in a position to answer that question. So apologies about that one. I want to pick up on Andres Vesca's question. You said that uncertainty provisions should be made, but how can these be quantitatively justified at in the risk margin or risk adjustment of IFRS 17 and Solvency II? And I think just to come back, I think we're not suggesting that you add an extra margin for uncertainty. We're suggesting, firstly, that you do talk about the uncertainty in your reserves and recognise just how difficult it is to estimate the right number or be confident that your best estimate reserves have an appropriate allowance for climate change. But we're also thinking that just because you don't have an explicitly named or identifiable climate change element, certainly on the liability side, particularly on occurrence form coverages, it would be potentially naive and possibly not the right thing to do, not to allow for or make sure you've at least thought through in a mental model about what is the potential liability that you might want to be allowing for and setting aside for climate change liabilities as they emerge. Okay, I'm going to move on to Mukami Jeru's question. Thanks for great insights. Should this be owned by the reserving team or the risk team? How do we avoid double counting in terms of managing reserve risk with respect to climate change due to the amount of focus on this specific element currently? So from a process and ownership perspective are the same. How, if at all, do you interact with risk management function in terms of reporting to the board and stakeholders? Who would like to pick up that one? Because I think it's a really good question about the, we know that risk teams are very active and it's a live discussion. And it partly speaks to why we called our presentation the emerging risk frontier. Josie, do you want to pick up on that?
Yeah, sure. So I think part of what I mentioned earlier is that this isn't just for reserving. This is interaction between reserving, capital, pricing, risk. It will affect the company much, much more broadly than reserving. And so take everybody along on the ride. I know that some companies have set up climate change groups which they work with across the entire organization. So it's different people from different areas of or functions of the company. They come together and have a think about how climate change might impact the business. So I don't think it's something for any specific area to own, but making sure that something is being done about it is key. So there will be certain things that actually, as you go through the analysis that we're explaining, it will come out that which is probably not something for reserving yet, but it's something where we should be making a capital allowance or something that we should be including in our ORSA instead of allowing for it in our explicit reserves itself. But yeah, I think it's something we should all work together with. Sorry, Alex.
Just saying the ORSA being the Solvency II own risk and solvency report that European firms are required to do.
Yes, sorry.
Yeah, I guess just to add on that, in my experience, I think the capital actuaries are already working very closely with our risk management team on a number of things. So maybe kind of looping in with them first to see, what overlap is already being done and how you can kind of piggyback onto it. As we've already said, we don't want to duplicate work, but we want to be working together.
Yeah, I think it does make sense. So from a risk management function perspective, the risk management function may have the helicopter view, may have the relationship with the regulator, particularly if it's a risk and compliance function. So it may be overall responsible for implementation of any climate related legislation or actually driving the climate effort within the company. And then I think, as my fellow presenter said, the risk management function could drive the effort, but it then links up to the other areas of the business to actually implement it and drive the necessary change and make sure that there is appropriate implementation at proportionate level across all the various areas of the business.
Thank you. Now, I think we've probably just got time for one more question. Unfortunately, we just have one more question on the list from Ryan Blake, which is what role might policy limits play in limiting insurers' exposure to climate-related risks? Would anyone like to pick up on that question from the panel? While you're having a think, let me share some comments. I think absolutely policy limits will help where they exist. Not all policies have policy limits is one of the challenges. And one of the challenges in just working out what the exposure might be is trying to work out what policy limits might be, particularly if you're dealing with historical policies and from years back where the data may not have been digitized in the right fashion. but absolutely policy limits might be useful. Also worth thinking if these are general liability policies from a long time ago, their coverage may have already been used on other tort claims, and it's sort of equally possible that the policy limits will be considerably lower just because of growing limits and line sizes over time. Did anyone else want to make any comments on that? I guess we'll probably look at some of these prior year issues.
Yeah, it's just certainly on the policy limits, it's worth considering whether they include defence costs or not, particularly on the litigation side of things, because that'll make a big difference. And certainly if you're a reinsurer or a legacy insurer, you might not have individual policy limit information. So again, you're going to be having to make certain assumptions there.
Right.
Also on like a forward look. I think on a forward-looking basis as well, though, if you, for example, you're pricing actuary, one of the things to look at is also if your underlying exposure is changing as well as a result of climate change. So your policy limit might stay as it was last year and you use the same rate online to price it, but actually because the underlying exposure has changed, that limit is now no longer what it was. Similarly, that you would do for inflation, but just assessing other risks as well.
Okay, so before I just make a couple of closing comments, I want to quickly whip around the panel and ask the question, sort of, if you're working for a firm where actually not that much has been done or it's not really talked about or recognised, where and how would you get started? What would be your first one or two actions? So if I start with Conrad, where would you go first?
Yeah, I would first go, what is the minimum requirement? So effectively from two areas. Are there any regulatory requirements that one needs to start thinking about climate change and the regulator is pushing against that? And then secondly, are there any reporting requirements that the insurer, that the company needs to start making? So yeah, bare minimum is the starting point.
Great, thank you. Josie, same question to you.
I agree with Conrad, but also I think if you're trying to get a bit of a better understanding, I mean, not to blow our own trumpet, but we did a paper last year that should help, and there's other stuff on our VLE that should help, and it will. I mean, our paper's quite long, but some of the mini papers should be quite quick to read through, and we reference quite a lot of other useful information if you wanted to go and have an additional read. So, for example, the Martin Lockman paper helps you to understand where your exposures might come from.
And Sarah, finally.
Yeah, so I agree with Josie and Conrad as well, but also just start having the conversations. If you can set up some sort of working group, even if you're only meeting 2-3 times a year to start with, to see, with people from underwriters, claims team, legal, just to see if anything is happening already. And if not, you can share ideas and hopefully get a bit of a snowball effect as you get the ball rolling.
Thank you all so much. So just to make a couple of final comments then. First, really thank you everyone for a great set of questions contributed, and thank you everyone for staying for so long for this session. I want to leave you with four takeaways that I hope are helpful. First, it really is time to get started. As you've seen from our survey results, the baseline really is progressing and the issues are starting to get closer. In this vein, and just echoing what some of the others have said, if you haven't, really, it is worth nominating a specialist within your reserving team who can focus on this and keep it under watch as an issue. Third, do engage with your board in a discussion about what their reserving philosophy or perhaps what their posture is and what it is to be. Are climate claims simply something to be on the emerging risk register, or is that just kicking the can down the road? We think there are some areas where possibly more needs to be done and some reserve liabilities need to be put on the balance sheet. But where should you have an implicit allowance and where should you be building up some sort of explicit IBNR? And finally, if you really are struggling to get started, we recommend that you implement a more granular approach. Rather than trying to boil the ocean, focus on specific areas where you can enhance your portfolio understanding and then build out from there. And now, it only remains for me to say thank you to our panelists, to Josie, to Sarah, and to Conrad. to thank Ryu for as being our moderator, and to the IAA for inviting us to present and for hosting today's event. Please do provide feedback. Really value it, whether through the IAA's survey or whether you just want to send us a message on LinkedIn or by email. We'd really love to hear from you and your experience and your thoughts on challenges and how you take this forward. But thank you very much, and thank you for listening today. Goodbye.
Thank you.
Thank you, Alex, Josie, Sarah, and Conrad. And everyone have a great day. Thank you.